My name is Jens Dieckmann. I'm the Vice President for Victims of the International Criminal Court Bar Association and Chair of the Victims Committee. Through this video, we want to give you an introduction into the ICC system of victim participation. The victim participation framework, established by the Rome Statute of the International Criminal Court, is a milestone in international criminal justice, which is part of a consistent pattern of evolution of international law, which recognizes victims as actors and not only passive subjects of the law, and grants them specific rights. At the ICC, victims are permitted to participate in criminal proceedings in their own right. That is, to make their views and concerns known to the judges on matters that concern them, rather than be involved simply as witnesses. This right is provided to victims under Article 68, paragraph 3 of the Rome Statute. Aware that no such allowance regarding victim participation was made at previous international criminal tribunals, Antonio Cassese, the first president of the International Criminal Tribunal for the former Yugoslavia, argued that the ICC system of victim participation recognizes that the victims of modern atrocities are, quote, central to the notion of international criminal justice, end of the quote. The framework of victim participation is key to the ICC's impact in affected communities, which, together with victims, are among the chief stakeholders in the court's work. Although only a narrow subset of victims in a given situation are likely to be recognized as victim participants, the ICC is effectively recognizing that the crimes alleged have impacted the victims when they are permitted to participate in its proceedings, incorporating their experiences and perspectives into the trial. Victim participation creates a link between the Hague and the victims, and in doing so, hopes to make the proceedings more meaningful and relevant to them. It has a potential to be a significant factor in ensuring that justice is not only done, but seen to be done by the victims. Ideally, contributions by victim participants to the trial, if properly structured, will also have forensic value. Participation in this context does not mean that victims have a role equivalent to the prosecution or the defense. Rather, they participate in a trial by presenting their views and concerns on particular issues at various stages of proceedings. For example, victim participants may be allowed to make opening and closing statements at the trial or provide evidence that assists the court to determine whether the accused is guilty. Article 68, paragraph 3, the Rome Statute provision governing the general right of victim participation, grants the court's judges considerable discretion to decide when and how victims participate to prevent prejudicing the rights of the accused. Although the ICC's responsibility to make participation as meaningful as possible does not displace other priorities, such as expeditious proceedings and the rights of the accused, it is not a responsibility that can be ignored without risking the court's legitimacy. Victims largely participate in proceedings through their legal representatives. This, in turn, means that the quality of the legal representation victims receive is essential to their meaningful and effective participation in ICC proceedings. Victims' legal representatives must have a range of competencies, including the ability to effectively engage and consult with victims in the field to understand their views and concerns, play a dual role in court by contributing to the proceedings through communicating the views and concerns of victims and providing victims with a point of reference and familiarity in an otherwise unfamiliar environment. ICC court decisions have repeatedly articulated the need to ensure that the participation of victims through their legal representative is as meaningful as possible as opposed to purely symbolic. Rule 90, paragraph 1 of the ICC Rules of Procedures and Evidence establishes a protection for victims' choice of counsel. Victims' choice matters because it can be a way for the victims represented to develop confidence that the counsel who stands for them before the court will represent their views, in turn building confidence in the court process itself. But choice is by no means the only or even the most important aspect of effective representation. However, numerous chambers have provided that the right to choose a legal counsel in Rule 90, paragraph 1 is not absolute. Rather, it is qualified by Rule 90, paragraph 2 and 3, which describe how common legal representation, it's the representation of victims collectively by a lawyer or team of lawyers, should be arranged. Common legal representation requires victims to join into group representation. The common legal representation framework is the primary procedural mechanism for reconciling the conflicting requirements of having fair and expeditious proceedings, whilst at the same time ensuring meaningful participation by potentially thousands of victims, all within the bounds of what is practically possible. Under Rule 90, paragraph 2, the court may require that common legal representation be organized where there are a number of victims to ensure the effectiveness of proceedings. Rule 90 sets out two ways of organizing a common legal representation. Under Rule 90, paragraph 2, the chamber may request that the victims choose a common legal representative with the assistance of the registry. Under Rule 90, paragraph 3, if the victims are unable to choose a common legal representative within a time limit that the chamber may decide, the chamber may request the registrar to choose a common legal representative. While Rule 90, paragraph 2 and 3 qualify the choice of counsel protected in Rule 90, paragraph 1, both the rules and the corresponding court regulations reflect a concern that the appointment of counsel remains informed by the choice of victims or by their interests. Finally, a chamber itself may use Regulation 80 of the Regulations of the Court to appoint a victim's legal representative where the interest of justice so require, and following consultation with the registrar, and, when appropriate, after hearing from the victim or victims concerned. The decision is not reviewable. Regulation 80's flexibility reflects these differences in language and that it is part of the Chamber's suite of inherent and express powers to take all measures necessary if the interests of justice so require. So, where are we today? The participation of victims at the ICC forms a reality and shapes ICC's daily courtroom practice. In this very moment, victims are actively participating at all levels of ICC proceedings. The first phase, the investigation phase, is a significant point in the determination of truth and justice, owing to the selection of charges and perpetrators for trial. The role of victims in this stage is necessary to safeguard their interests as well as to provide public scrutiny and accountability. At the ICC, the prosecutor is obligated to consider and respect the interests of victims in investigations under Articles 53, paragraph 1, subparagraph C, and Article 54, paragraph 1, subparagraph B of the Rome Statute. The prosecutor is also obligated to inform victims when deciding not to initiate an investigation or prosecute under Article 53. Unlike national courts, victims before the ICC have no right to initiate criminal investigations or prosecutions. Additionally, Article 68, paragraph 3 of the Rome Statute does not specify whether they can participate in investigations just in proceedings determined to be appropriate by the court. But ICC jurisprudence clearly decided to integrate victims even at this early stage in the proceedings. One recent example. At the stage of preliminary investigations regarding the registered vessels of Comoros, Greece and Cambodia, the ICC prosecutor decided not to open an investigation pursuant to Article 53, paragraph 3, subparagraph A of the Rome Statute. On 16th July 2015, the Chamber, following a submission of 2 sets of participating victims, requested the prosecutor to reconsider her decision not to initiate an investigation as soon as possible, and once the prosecutor had taken the final decision, she should notify the Chamber, the Comoros and the victims. Although in the preliminary investigation related to Afghanistan, the Chamber ordered that the Victims' Participation and Reparation section of the ICC implements procedures for victim representation. Participation in the trial stage can offer victims the opportunity to have their interests considered by the court in relation to clarifying the facts and determining the responsibility of the accused. The legal representatives of victims have brought to light the context of victims' harm, the continued difficulties they face, their needs and expectations, and presented evidence on the culpability of defendants. So in all ongoing trial procedures at the ICC, Gbagbo and Blegude, Ntaganda, Ongwen, Bemba and Banda case, thousands of victims are participating, represented by counsel, common legal representatives, or counsel from the OPCV, assisting the court in its mission for truth and justice. Finally, victims are participating also at the final stage of proceedings, the reparation phase. In all three cases at the reparation phase, Almadi, Katanga and Lubanga, there are appeal procedures ongoing, and in all reparation appeals, victims are entitled to participate and to raise their views and concerns. This is key. Reparations can only be meaningful and effectively answering the harm suffered by the victims when victims can actively participate also in this final stage. At the opening of the Rome Conference on the Statute of the International Criminal Court, United Nations Secretary General Kofi Annan stressed to delegates that, quote, the overriding interest must be that of the victims and the international community as a whole, end of the quote. The resulting victim provisions within the Rome Statute include a number of provisions for victims, including recognition, participation, protection, reparations, and a trust fund. The inclusion of these provisions placed victims at the heart of international criminal justice. After almost 20 years since the Rome Statute was adopted, and after more than 16 years of active proceedings before the International Criminal Court, it is no longer questionable whether victims have found their role at the ICC and contributed to its mission to seek justice and fight against impunity.